from 17 to 45.
27. Item number 27.
27. No, it is a 2017 matter.
Yeah, not to be left.
बताइए क्यों आज क्यों एडजस्ट करें?
Our main counsel is not in which time?
Next week रखो उसको. Next week. Date देगा Monday, Tuesday जो.
Serial 32, Your Lordship, I pray for 1 week time to file a rejoinder affidavit. Yesterday, a counter affidavit has served.
2 weeks to file rejoinder. 32.
32.
My Lord, seal number 25, pray for 1 week.
1 week. 2 weeks.
Thank you. 25.
Yes. Many other mentioning up to 45. Then from 46 to 64.
Item number 49, 2 weeks.
49.
2 weeks.
All right. 2 weeks.
Serial number 64, my lord.
64.
Lord, it may come after 2 weeks.
2 weeks.
My lord, serial number 61 or 63, 1 week time. 61.
दोनों 2 weeks के बाद. 65 to 79.
Lord, item number 78, my lord. It relates to Aryabhat Knowledge University. The other matter is listed at serial number 4. On last occasion,
78.
78, my lord.
You want it to be heard with 4?
My lord.
All right. So when the 4th number is called, you mention.
All right.
Yes.
My lord, number 68. In this case, earlier respondent was for 50%. Your lord, any before lunch?
All right. 68 को urgent mark कर दीजिएगा. Call him at 12:30.
My lord.
1:15.
My lord, as earlier directed, I am submitting all the original records related to Amod Parmar.
Yes.
And I have also prepared a summary for your lord.
You were not supposed to come. All right.
My lord, serial 13, my lord, 1 week time. Serial 13, my lord, 1 week time. Serial 13, my lord.
Finishing is over.
My lord, I.
God is still on the other side.
Lord, serial number 37.
Mentioning is over.
Along with serial number 37.
Mentioning is over.
Serial number 65 is to be tagged, Lord.
Mentioning is over, I am saying.
Obvious item of 1.
It's over. We have kept that because it's on the side. Case has been called.
On judgment, 1.
We have discussed and held that the action was bad, but no relief can be granted to you. In view of above discussions, petition is not entitled to any relief as pre-responded. Petition is disposed of with directions to respondents to release the retirement benefits of the petitioner, if any, no cost. We'll go through it.
For orders 1, item number 2, along with analogous case.
Lord, with folded hands, my lord, on behalf of my lord, the then DO, my lord, and my lord, I have my lord, filed my lord, second so-called my lord, in which my lord, the then DO has my lord, unconditional my lord, apology my lord, filed.
Where have you filed it?
My lord, yesterday itself, my lord, filed that is in record, my lord, second so-called, as per your lordship's direction, in second case, my lord. Lord, and onwards, my Lord, I have
Order reserved. You pass and all. Because the condemner is present along with his counsel. Filed a second show cause, tendering unconditional apology. Order reserved.
Item number 3, Mr. Amrinder Narayan Roy.
Petitioner is a MBBS doctor and he appeared in final examination of postgraduate degree MD theory examination, my Lord. My Lord, after examination, he was declared failed by only 1 mark, my Lord. Although marks has already been given, when he obtained copies, answer copies through RTI, my Lord, it appears that marks has already been given.
What is their counter? What do they say?
In counter affidavit, they have accepted that they have committed mistake, but they are not ready to.
Where is their
Yes, my Lord, paragraph 13 and 14 relevant part
of the counter affidavit of?
Counter affidavit of
Respondents.
only one counter affidavit respondents to the paragraph 13 and 14.
My lord,
My Lord, may I permit to read, my Lord? Paragraph 13 and 14. That the scrutiny committee did not recommend any change in the marks of the petitioner for good and valid reason. The entire confusion has erupted due to the mistake of the scrutinizer, checker of the already evaluated answer sheet of the petitioner. That by mistake the answer to question number 4C of paper 2 was marked as 5 marks without seeing that already awarded 4 marks by the original evaluator. It is absolutely misleading a statement, my Lord. If my Lord permit me, I will show with the answer sheet.
my lord, in this case, Mr. Anand Kumar.
Where is the statement of the concerned scrutinizer?
My lord, in this case, Anand Kumar was there to argue in this case, Your Lordship. He is from the Harvard University, Your Lordship. He is on leg, Your Lordship, so it may be possible for few cases.
Possible.
For few cases.
Item tomorrow. Item of 4. As paid by the council for the cheaper.
My Lord, item 78, he also taken up along with this plot.
Yes, what is the case?
Lordship, may I please? This writ petition is filed for re-evaluation of the answer book of the student of postgraduate MD MS
What are the IAs pending? You have moved an application for listing of the IAs.
Lordship, other petitioner.
First IA for what?
Lordship, the IA are the same. The doctors has come after some time. So I filed an I through IA Lordship to make a party parallel to the other rate for the rate only. The same doctors are the petitioner in rate petition. Then again Lordship in IA two other doctors have come to come party.
Petitioner?
Lordship.
How can that be? You can only file a fresh petition for this.
Actually Lordship टाइम नहीं था उस समय तो हमने
That doesn't matter. अभी और कौन सा टाइम मिला आपको? You can't include petitioners as parties in the petition. Where is their affidavit in support of the submission, which has already been made in the writ petition? That is why petitioners are not included. Order 1 Rule 10 is not applicable simply as it is with the writ petitions. Writ petition is filed by a particular petitioner. How can somebody know I am also petitioner in that case? He can file a fresh petition. That petition can be tagged along with it, but not as a to be included as a petitioner.
Given the affidavit. The Lordship may be
number
allowed
1 of 22 and 2 of 22 have been filed by similarly placed other doctors who claim that they should be also treated as petitioners to the present writ petition. Learned counsel submits that because there was a paucity of time, so the IAs have been filed. This court finds that the application is wholly misconceived. A person who has a personal grievance or wants his grievance to be redressed has a right to file a writ. The writ petition is supported by the affidavit of the said petitioner. No other person can claim to become a petitioner in a writ petition filed by someone else. If any other person also has a similar grievance, he or she has always a right to file writ petition for redressal of his personal grievance. Allowing the applicant to move a fresh petition for redressal of their own grievance. The IAs number 1 of 22 and 2 of 22 are dismissed as misconceived. When the order is being passed, you don't want to hear it. Chali. Let this writ petition be listed for arguments. Finally, on read is completed.
Yes. We have filed. He has not filed rejoinder.
Rejoinder मैं बना दिया आज दे देता हूँ. Actually,
Learned counsel for the petition.
कल रख लिया जाए.
Court's time to file rejoinder. He may do so within a week. List this case after 1 week. Date दे दीजिएगा.
Next Wednesday.
18th week. Next week. Next 8 week के बाद दीजिए 24th to 25th.
Lordship 18th
मैटर भी यही है.
Lordship 25th को मैं हूँ. Lordship उसके पहले वाले हफ्ते में रख लिया जाए 18 या 19 को Lordship.
So many. How do you matter?
Lordship
You will have to find out time if you want to argue a case.
1 तारीख को रख.
Sorry.
Item 17
It will be on
is also
26th.
similar, my lord. That is CWJC 181.
CWJC.
One request was there, my lord, since a counter affidavit has not been filed by the respondents, they may file the counter affidavit within a week so that I
You're
may
not
answer.
in that case?
In that case, Doja appears, Your Lordships. He has been allotted this. I'll convey this to him, Your Lordships.
We will take into consideration this count.
Fine. Because issues are common, my lord. Issues are common.
Item 8, Purushottam Kumar Jha.
granted promotion on the post of senior lecturer, Milords, in the Tilkamani Bhagalpur University, whereas at that point of time he was not in the services of Tilkamani Bhagalpur University. Right, annexure
grievance.
Milords, cancellation of the promotion of the private respondent. Respondent number 6.
He was granted promotion in 2013. You are challenging it after so many years.
Milords, recently I have learned he was granted promotion in 2013 with effect from 14/8/2007.
Yes.
Whereas he was not in the services of the Tilkamani Bhagalpur University as on 14/8/2007.
How is it affecting you?
Milords, ultimately seniority will come into picture, and this gentleman, this gentleman,
How you are being affected?
this gentleman, while
Which gentleman?
holding respondent number 6.
We want to know what are your facts. You first tell us about yourself.
Milords,
What is your locus?
my locus in this
इनका अपॉइंटमेंट खुद गलत है कि PIL है, इन पे इंक्वायरी चल रहा है, चाहे behalf of यूनिवर्सिटी में लो। इनका
अपॉइंटमेंट खुद गलत है। R21 R कैटेगरी में है, एक PIL किया था, उस पे इंक्वायरी सेटअप है, इन पे आदेश चीफ जस्टिस का ऑनरेबल चीफ जस्टिस का ऑर्डर है जो इसको देख लिया जाए। इन पे इनका खुद अपॉइंटमेंट गलत है। रिस्पोंडेंट नंबर 6 को चैलेंज कर रहे हैं।
PIL फाइल हुआ है रिगार्डिंग अपॉइंटमेंट।
PIL फाइल हुआ है कि SLP
या PIL एंटरटेन होता है सर्विस मैटर्स में।
सर्विस मैटर में नहीं था, SLP मतलब होल हुआ है, इनमें नहीं है।
I want to know from you, PIL is with regard to the nature of appointment.
नहीं, वो इलीगलिटी के लिए, फाइनेंशियल इरेगुलरिटी के लिए हुआ था, उसी में से ये आते हैं, इसके लिए नहीं।
Yes, what is your locus?
My lord, respondent number 6 while holding the post of the.
We are again asking you first give us what is your locus?
I am also a teacher, Milords.
What post are you holding?
I am also holding the post of associate professor in Tilkamani Bhagalpur University in the same department.
In department of?
In department of psychology.
Where have you said?
My lord.
You are in another college, a constituent unit.
My lord, I was in a constituent unit, Milords, Sabor College, Sabor.
At what?
And Milords, the respondent number 6 was initially appointed in.
How are you concerned with him?
My lord, my lord, my lord.
How is it affecting you?
After me, he will become.
After you, no? Not before you.
Basically, my lord, I'm sorry to say, my lord, I have not disclosed as to
The lawyer for the petitioner shall file an affidavit to show his locus for challenging the appointment and promotions of respondent number 6. List after 3 weeks.
Item 9. Sharan Kumar.
I am challenging the part of the impugned order, your lordship, that is जो कि हुजूर है annexure 22 पर हुजूर, इसमें हम पार्ट ऑफ द ऑर्डर को चैलेंज किए हैं जो कि पेज नंबर 73 पर जो है इसको कर दिया गया है हुजूर कि she will not entitled to payment of salary for the period he not work in any school, but she is entitled to job. No proceeding has been initiated.
Which page is the order?
Page number 73 of annexure 22, your lordship. Page number 73. My lord,
may I permit to read, Your Lordship. Since the employment of the appellant has been terminated, she has been deemed to be continue in service as the panchayat teacher / block teacher. However, since the appellant has voluntarily not worked any school after 1/3/2009 on the plea that he was treated physically harms on her.
What is the error in the order? Page 73, no?
73.
Since the employment of the appellant, please read that.
Yes, Your Lordship.
She has voluntarily not joined anywhere. This is the finding.
Yes, Your Lordship.
On the test that she was apprehending that something may happen to her. So she did not join.
हम तो हुजूर ऑलरेडी एप्लीकेशन देते, एक नहीं हुजूर कई एक एप्लीकेशन दिए हैं हुजूर, इन टू भी कहे हैं, सर्विस भी कहे हैं, कोई ऑर्डर हमारे अगेंस्ट में नहीं हुजूर है, नो प्रोसीडिंग चला है।
Join at middle school Kanohar, Manigachi, on the threat of physical harm to her. Which you have said.
हम हुजूर हम दिए, कॉन्ट्रैक्टर वहाँ मिड डे मील वाला में था हुजूर, उसमें आकर के धमकी दिया, स्कूल बंद कर दिया, हमको धमकी दिया, हम थाना को भी लिखे, एसपी साहब को भी लिखे हुजूर, डिपार्टमेंट को भी लिखे, हमको एडजस्टमेंट हुआ हुजूर 1 महीना के लिए, फिर दोबारा ट्रेनिंग में भेजा, ट्रेनिंग के बाद फिर आए, हम एप्लीकेशन दिए हुजूर, उसके बाद नहीं शो काउज पूछा गया, शो काउज के रिप्लाई के बाद कहीं कुछ हुजूर जैसे हमको नहीं किया गया, तो हम हाईकोर्ट में रिट फाइल किया, लिबर्टी मिला हुजूर, डिस्ट्रिक्ट अपीलेट अथॉरिटी के यहाँ, डिस्ट्रिक्ट अपीलेट अथॉरिटी ब्लैंकेट ऑर्डर पास कर दिया हुजूर, उसके बाद हम स्टेट अपीलेट अथॉरिटी में चैलेंज किए हुजूर, दैट हैज बीन सेट असाइड योर लॉर्डशिप, बट ओनली पार्ट ऑफ दैट ऑर्डर आई एग्री विद योर लॉर्डशिप। स्टेट अपीलेट अथॉरिटी के ऑर्डर हुजूर, डिस्ट्रिक्ट अपीलेट अथॉरिटी के ऑर्डर से हुजूर हम थोड़ा सा दिखा देना चाहेंगे हुजूर। पेज नंबर 60 पर हुजूर आया जाए थोड़ा सा, डिस्ट्रिक्ट एनेक्सर 21 है हुजूर, पेज नंबर 60 से स्टार्ट होता है हुजूर, जिसमें 61 पर ऊपर में है हुजूर। उपयुक्त विषय के जाने के बाद उन्होंने दिनांक 17/4/2018 को समाहर्ता दरभंगा एक आवेदन देकर अपने जीवन, इज्जत, आबरू की रक्षा करते हुए गुहार लगाई। आवेदन की प्रति उन्होंने पुलिस अधीक्षक दरभंगा एवं थाना प्रभारी महीनेगाछी को भी दिया। सो हुजूर हम एक दिन भी बैठे नहीं हुजूर, हम लगातार हुजूर पिलर टू पिलर हुजूर दौड़ रहे हैं हुजूर, इलीगली रिस्ट्रेन कर डिस्चार्जिंग ड्यूटी योर लॉर्डशिप। सो पिटिशनर हैज नो एनी there is no concept of automatic termination your lordship. On that issue your lordship has already decided the Honorable High Court your lordship. So my lord kindly may permit to produce the order your lordship of this Honorable Court. That is reported in 2019 volume 4 PLGR page 166 your lordship.
You filed your counter?
My lord.
Is not required to be given to any other person. Notice देना है किसी और को? और is your reply sufficient for all?
मैं थॉट किसी प्राइवेट पार्टी को तो नहीं बनाया।
प्राइवेट नहीं हुजूर,
लेकिन इनका काम ही नहीं।
सुन लेते हैं। Yes. Yes, what was your case?
लॉर्ड इनिशियली हम हुजूर अपॉइंट हुए पंचायत टीचर में हुजूर, उसके बाद हुजूर वहाँ मिड डे मील प्लस बाउंड्री वॉल के लिए कॉन्ट्रैक्टर हुजूर वहाँ आवेदन दिया, जो कि सब चीज़ था हम फॉरवर्ड किए हुजूर अथॉरिटी, ऊपर के अथॉरिटी में हुजूर, उन्होंने धमकी देने लगे, स्कूल में ताला लग गया हुजूर। उसके बाद हम रिप्रेजेंटेशन, सेवरल रिप्रेजेंटेशन हैज बीन फाइल्ड बिफोर द अथॉरिटी कंसर्न योर लॉर्डशिप। लास्ट उसमें हमको बीच में उधर हमको 1 महीना के लिए हमको दूसरे जगह ट्रांसफर कर दिया गया। उसके बाद हम ट्रेनिंग में चले गए हुजूर। ट्रेनिंग के आने के बाद हम लगातार देने के बाद हुजूर हमको एक शो काउज पूछा गया, जो कि हुजूर है पेज एनेक्सर 18 योर लॉर्डशिप, एनेक्सर 18 हम शो काउज का हुजूर रिप्लाई, डिटेल रिप्लाई हम दिए हुजूर एनेक्सर 19 में हुजूर। 19 के बाद हुजूर नो एनी एक्शन हैज बीन टेकन योर लॉर्डशिप ऑफ माय reply your lordship, then I move for
election
एनेक्चर 18 से हुजूर हमको सो काउच डीपीओ साहब पूछे
Annexure 19 is that page?
एनेक्चर 19 इज द पेज नंबर 56 योर लॉर्डशिप.
What do you say in this?
इसमें सारा फैक्ट हुजूर हम देख दिए, उसके बाद कोई एक्शन नहीं लिया हुआ.
What do you say? सारे facts का मतलब?
Yes, your lordship, may I permit to read?
You are arguing or just?
लॉर्ड पढ़ते हैं महाशय निवेदन.
Tell us what do you say about your being absent after 2009?
कि माय लॉर्ड देते हैं हुजूर. मैना गाछी
साजिद करते हुए लिखित आवेदन नहीं मिला कि मौखिक रूप से भुगतान करने से मना करने पर विद्यालय में उत्पन्न विषम स्थिति तथा रंगदारी टैक्स मांगने, गाली गलौज करना, फतवा कसना, विद्यालय हम एक ही वहाँ पर टीचर हुजूर थे, हम महिला हैं हुजूर. पासवान ललित पासवान द्वारा जबरन गाली गलौज के गिट्टी बालू छड़ घटिया सीमेंट गिरने का विरोध करने पर विद्यालय में मवालियों द्वारा
Come to paradigm of your show cause. Page 56.
Yes, your lord. In Excerpt 17, 18, your lordship.
You just told.
Yes, your lordship. उपयुक्त विषय के करना है.
Para 9.
9. सुरक्षात्मक दृष्टिकोण से मेनावशी का नौकर योगदान देना संभव नहीं है.
उसके
बाद हुजूर हम उसके बाद हुजूर हम कुछ नहीं उसमें हुआ हुजूर कहीं.
Have you lodged any FIR against the contractor?
ऑलरेडी हम हुजूर अब दिया
lodged an FIR against the contractor?
हम लिखे हैं हुजूर.
आपसे जो पूछ रहे उसका जवाब दे दीजिए. Have you lodged any FIR?
FIR लॉन्च नहीं किए हुजूर, लेकिन हमने एप्लीकेशन दिए पुलिस.
Nobody else is required to, unless you want safety, you'll have to go to the police. Not your district education officer.
जो कि डिस्प्यूट नहीं आया है हुजूर. हम
Anything else?
हुजूर एक जजमेंट हुजूर है कि देयर
आप क्लेम भी अपनी सैलरी तब तक की करिए. कम टू पैरा 6 ऑफ दिस योर रिप्रेजेंटेशन. 6 अभी जो पढ़ रहे थे ना, उसका पैरा 6 भी पढ़ लो.
मेरा बकाया राशि लगभग 58,134 रुपया भुगतान के हेतु बार बार आग्रह करती रही, लेकिन
यही है 58. ये अब 2009 तक का ही है. आगे भी आपने लिखा है.
जस्ट अभी जो दिए हैं रिमाइंडर काउंटर फाइल के इसका
सॉरी
थोड़ा सा देख लिया जाए जो जजमेंट दिए हैं हुजूर कि देयर इज नो कांसेप्ट ऑटोमेटिक रिमूवल, उसका कॉन्सिक्वेंस मिला है हुजूर.
You will take into consideration.
हुजूर किया गया, हम बराबर देते रहे कि कहीं भी हमको एडजस्टमेंट कर दिए. जैसे जो माय राइट योर लॉर्डशिप टू ट्रांसफर एनीवेयर योर लॉर्डशिप, वहां मोडेस्टी का हुजूर देखा गया कि ताला बंद कर दिया गया है हुजूर. कॉन्ट्रैक्टर साहब
by way of this petition has challenged the order passed by the state appellate authority dated 25/2/2020, whereby appeal filed by the petitioner has been partly allowed and directions have been issued to the respondents to reinstate the petitioner and allow her to continue and post her at a different place other than the school where she was lastly posted, and has also granted her continuity of service, but has refused to her entitlement for payment of salary for the period she had not worked in any school. Learned counsel for the petitioner submit that the petitioner was forced not to join the upgraded middle school, Panokhar, Manighachi, as there was a threat of physical harm to her,
application police
for which she had made a complaint to the her superior officers, but no action was taken at their level. Learned counsel submits that as the petitioner was apprehensive of bodily harm, she did not join at the middle school. Learned counsel submits that the services of the petitioner were never dispensed with, and there is no concept of automatic termination.
Yes, sir.
He relies on the judgments passed by the coordinate bench in case it's reported in 2019 for PABR 166, Nasheha Shahar Rizvi versus State of Bihar. Learned counsel submits that the petitioner, the state appellate authority has erred in not granting the salary for the period from 2009 up to the date of passing of the order. Learned counsel appearing for the state submits that the petitioner has voluntarily not joined her duties and merely on the basis of apprehension, she cannot claim not perform duties and obey the orders of posting. I have considered the submission. It is a case where the petitioner had been working as a block teacher at a particular panchayat, Manigachi. She had been transferred to the block employment by the block employment unit Manigachi to middle school Kanokhar, white order dated 15th February 2009, and she was required to join at the place, but she has refused to join on the apprehension that the concerned midday meal contractor has threatened her. She has submitted representation that she may be adjusted into another school. It is submitted by her that under Rule 15D, the appellant has a right to avail facility of a transfer adjustment in another school, and the concerned employment unit was obliged to consider the representation and transfer her to another school and take appropriate decision as per the rules. The respondent, however, did not accede to her request, and a show cause notice was issued to her, to which she submitted her reply, pointed out her difficulties. She also claimed that her salary has not been released up to the period of 2009, and she specifically mentioned that she will not join at the place of posting granted to her by the employment unit. The state appellate authority, when nothing happened, she filed a writ petition before the court, which was remanded to the state appellate authority.
District appellate authority.
District appellate authority, and the matter travelled to the state appellate authority. The state appellate authority has granted part relief to the petitioner, holding that the petitioner was entitled to be posted at any other place, and her request ought to have been considered by the employment unit. The state appellate authority has further directed the concerned employment unit to take a decision and post her at the place of her choice. However, so far as the claim for salary for the period from 2009 up to the date of passing of the order is concerned, the court the state appellate authority has refused to release the salary on the ground that she has not joined at the place posting. Para, in the opinion of this court, no government or employee can refuse to comply with the court's order, by the orders of their employer, even if the order may create unsuitable circumstances for an employee. He has to join and may make a representation with regard to his difficulties. If a different view is taken, in all cases of transfer, employees may choose not to join and make representation and sit at home. In the present case also, the petitioner has since 2009 not performed any duties in any school. The state appellate authority has granted leverage to the petitioner and allowed her continuity of service from 2009 up to 2020. That is the time when the petitioner has remained out of duty at her own will. If a person thinks that there is any apprehension with regard to bodily harm, he or she ought to have taken recourse to the law providing for registering of any FIR against any particular individual against whom the apprehension exists. But no such action has been taken by the petitioner, and merely by mentioning in a representation to her superior authorities, she does not get a right not to join the school. In these circumstances, the contention raised by the petitioner are found to be without basis. The order passed by the state appellate authority does not warrant any interference. The petition is misconceived and accordingly dismissed. Next case.
एक चीज बोलना चाहेंगे जो हमने एसपी साहब का उपयोग थाना में लिखे दिया नेक्चर 4
Item number 10.
ऑब्लाइजेशन
Vishalan Pandit.
My lord, I just received the counter yesterday. I seek a time for rejoinder.
Cause reply आ गया केस पे.
ये फाइल
When counsel for the state appellate they filed a counter appeal to counsel for the petitioner wants time to file a rejoinder. The registry is directed to place the counter appeal and rejoinder on record put up after 4 weeks.
Item number 11.
The panchayat, the petition number 1 is panchayat teachers. Number 2 is the block teacher and 3 is the 2 is Nagar teacher and 3 is Nagar teacher. The petitioner already.
How are they similarly situated? You filed a joint petition.
All are similarly situated. There is case for
You just now said one is panchayat teacher,
my lord.
other one is a Jila Parishad teacher.
Nagar teacher, my lord.
So they are governed by different rules.
No, the rule is there, my lord. Our case for lordship only consideration there, my lord.
What have you come for?
My lordship for payment of the annual increment. Who the petitioner already passed central will test and teacher training examination, my lord.
Go to Suresh Ram. An individual.
One lordship, but it will only thing.
We will not entertain such a petition here. Our different teachers of different governed by different rules.
The rule, as per the rule, there, the selection, they are not.
You want me to say that?
My lord. There is common decision there, my lord. There is common decision, my lord. The respondent issue. there is my lord, that
petitioners are admittedly
may
holding posts under different rules. One is a panchayat teacher while the other one is under Nagar Parishad.
Nagar teacher.
Both the
And block teacher. The block teacher and panchayat teacher belong to my same guideline.
petitioner number 3 is a block teacher. Service conditions of a block teacher and panchayat teacher are governed by the panchayat rules of 2020, while the service conditions of petitioner number 2 are governed by the Nagar Parishad service rules of 2020. नाम पूरा अलग अलग है.
वो एक परमिशन लिया है सब.
The claim of pay and allowances and increments. Annual increment
On the basis of the passing the teacher test
is to be examined in terms of the service conditions of their respective rules. Keeping in view thereto, a joint writ petition was not maintainable by all three of them together. That apart, that claim can be raised by the petitioners before the concerned district appellate authority, state appellate authority, as laid down by this court in Suresh Rao's case. Keeping in view thereto, this writ petition is dismissed with liberty to avail. Dismissed. This writ petition is not maintainable. That's why we have dismissed.
Lordship only Lordship may permitted the down my lord, Lordship liberty to my file.
आपको पहले
I'm sorry, my lord. I'm sorry.
that sorry is gone. Open court dictation is not to be withdrawn. Sorry.
Lordship
The court of record, Mr.
May it please my lord. It's a case similar to Ataur Rahman.
Both the counsels
In category B, my lord.
are admitted that the issue raised by the petitioner is covered by the adjudication of this court in Ataur Rahman's case. Category B. Accordingly, the writ petition has, as the petitioner has not qualified the exam, the writ petition is dismissed.
Item 13.
Ataur Rahman का रिपोर्टिंग हो गया ना, बस वो डाल देना, उसको कोर्ट पास करना पड़ा.
My lord, for ACP benefit of the petitioner, my lord, second term of permission has not been given to the petitioner. Although petitioner is retired from the service, my lord. Only the limited ground.
Yeah?
Second, time bound permission. The monitoring benefit has not been given, my lord. Only,
When was to be given?
my lord, 1981, the first time bound permission has been given, my lord.
The petition has been filed for grant of benefit of second time bound promotion due with effect from 1/4/91. Writ petition has been filed in the year 2022 without giving any cogent reasons for not approaching this court earlier.
Retired.
While the petitioner retired on 2/6/2005 and her retirement benefits were also released in 2006, she has not raised any grievance since then. More than 16 years have passed by. 18 years have passed by since retirement. Writ petition is just or on ground of gross laches and delay, keeping in view the judgment passed by the Supreme Court in M.R. Gupta versus State.
Item 14. Supreme
Then may be approached before the authority, my lord.
94 का Supreme Court का judgment है. I can't do anything about it.
But sir, I'm not facing the Senate application and permission to withdraw it.
Council says the council does not press the writ petition, dismissed as not pressed.
Item 15. Mark Kaushik.
May it please your lordship. The petitioners were working under a project on contract basis. Regular appointments are being made and therefore their appointments are being cancelled. My lord, my submission, although the entire proposition of law is against me, it is based only on two aspects which my lord will consider. There is a gazette notification contained in Annexure 12 by which the government of Bihar accepted the recommendations of three-man committee formed for the purpose of ascertaining the service conditions of contractual employees. One of the recommendation which was accepted was that if a project is completed or if regular appointments are made, even then they can be accommodated against the vacancies in other departments by virtue of a fresh arrangement, fresh contract. My lord will only see, since it has been accepted by the state government with respect to science and technology department also. On this limited aspect, I press my case.
What is your prayer?
My lord, the regular appointments are being made by virtue of a selection process conducted
You participate in them? Who is stopping you?
We participated.
And you have not been able?
We have not succeeded.
Then?
Exactly the same situation is being contemplated by the gazette notification which
It is prior to. If suppose before the selection process, had you been allowed some bonus marks or some additional leverage, then it is another thing in terms of that gazette notification. But once you have participated with open eyes and in open competition you are there and you are not successful, that's enough.
Since my lord, it says that those who are not successful, they can also be accommodated if there are vacancies.
It is not for the selecting body to consider that.
So we only want to continue on contract basis because the seats are there. All seats have not been filled up. That is the second set of contractual.
You are working
as assistant professor. And there are two sets of contractual employees, one who were appointed.
Have you brought that judgment press code where they said that was Lecturers Association? It went from Bihar only.
I'll get it in that case.
Where's the judgment? If there are vacancies which you have not filled up, then they may be allowed to continue on that.
Till the regular appointment is made on.
Yes.
But in fact, in the
already have been working on ad hoc basis. That is a settled law.
Settled law is that when the contract appointment.
File your reply.
Contract appointment could not be substituted by contract appointment.
All right, but suppose you have not filled up those posts by regular selection, and there are posts lying vacant, let them continue against those vacant posts. Of course, wherever you have got there regularly, they will have to give.
We will file affidavit.
File your reply. There is a judgment coming from Supreme Court. We have to prepare. So what is happening to you? Young people not preparing cases with judgments?
I'll get it. Obliged.
Item number 16, Mr. Madhav Raj.
My lord, similar and identical issue have been decided by your lordship on order.
What is the issue here?
My lord, the issue is that the petitioners have not been issued certificate of training before 31st March 2019.
Okay, so they come under category B?
Category C or D, your lordship.
All right, same.
And my lord, कनेक्शन 7 हमने लगाया है, my lord, उसमें हम लोग का वेतन रोक दिया गया है, my lord.
वो तो dismiss होने के जो those who have not passed, we have said they will not.
We have passed, your lordship, but NC has not been issued. Training certificate has not been issued.
लिखिए, the petitioner thinks that they have passed the training, but the certificate has not been issued.
My lord, और एक annexure हुई
In Ataur Rahman case, this court has held as under. The case of the petitioner stands adjudicated in view of the above.
बस एक annexure हुई है. हम लोग का पे स्केल फिक्स किया गया ट्रेनिंग सर्टिफिकेट दिखाने के बाद कि हम लोग पास कर गए हैं, बस इशू नहीं है. वही कैटेगरी सी में माय लॉर्ड हम लोग का जम
कर रहे हैं कैटेगरी
ऑब्लाइज.
This petition stands disposed of accordingly.
Item 17. Kumar Jha.
Notes in this case, the petitioner is an assistant professor in GNB Law College, Bhagalpur, in the Department of English. His services came to be absorbed in laws pursuant to the recommendation of the Honorable Agarwal Commission. My Lord may have a pleasure to go through page number 35.
Why has salary been stopped?
No reason has been assigned.
But you have some reason with you.
My lords, on account of the two letters of the state government which says that the teachers working against R2 and in NR posts be not paid their salary. I do not fall within that category. In spite of that, my salary has been stopped. And my lords,
The calls for the petitioner submits that the
in a similar case, my lords,
petitioner does not fall within the category of those whose salary has been stopped by the state government. Despite thereto, the petitioner has been wrongly added and included in the category of R2.
R2 oblique NR, non-recommended post.
R2 and oblique not recommended post.
Annexure 4 at page number 35 shows that I am against R1 category post.
Petitioner has relied on
Agarwal Commission report.
the Agarwal Commission report and taking this court to annexure 4.
Page number 35. Serial number 30.
To show that the petitioner has been shown to have been working since 20th January 1986 and comes within the category of those who come in R1 category. Issue notice. Council appears for the university. Shall file its reply. In the meanwhile, the petitioner's salary shall not be stopped and he shall be paid his salary regularly.
Right. 1 of January 2022 salary has been stopped.
अभी आगे की भी स्टॉप करेंगे इसके लिखा है बाकी एरियाज बाद में देखेंगे.
Item 18, Sharam Chatterjee.
Lord, in terms of the order of the Honorable, the petitioner was appointed by the Annexure 5 at page 27. And after 6 years, Lord, by Annexure 1 at page 23, I have been terminated from service, questioning my training degree, Lord. So exactly identical matter, Lord, has been allowed by your Lordship. Ashok.
Learned Council relies on the judgment passed by this court in the case of CWJC 17345/2016. Challenge Kumar versus State of Bihar, decided on 19/12/22. And submits that the termination order is only illegal and unjustified. Issue notice. Council appears for the state shall file its short supply list again after 2 weeks. 3 weeks के बाद डेट दे दीजिए या फिर उनको वापस
7 February. 7 February. Item 19, Mr. Kumar Kaushik.
May it please the Lord. Lord, the petitioner has come against the order by which the private respondent has been appointed in charge headmaster. My Lord, the decision of the government in this regard, the petitioner joined in the year 2007, whereas the private respondent joined in the year 2010. But he joined as a trained teacher and petitioner acquired training in the year 2015. In 2014, the notification was that it will be from the date of joining. Then it was changed in 2019 that it will be from the date of joining or the date of training, whichever is later. So that notification is against me. Thereafter, my Lord, in 2021, headmaster appointment rule had come, which prescribed that 10 years experience is required for a teacher to become to participate in the selection process, but that 10-year experience would also count from the date of training. That notification was also against the case of the petitioner. Thereafter, in exercise of powers under the rules for removal of difficulty, the government decided that it will count the experience for permanent appointment, participating in the permanent appointment from the date of joining and not from the date of training. And thereafter the advertisement was also rectified and amended, and I have been able to participate in the selection process which has not attained finality. Therefore, if in the final selection process for the post of headmaster, experience is being counted from the date of joining, for the purpose of in-charge headmaster also my submission is that earlier notification would lose its significance in view of the new notification which has come in exercise of powers under the rule for removing the difficulties.
But that power is exercised specifically for the purpose of recruitment.
For the purpose of recruitment.
But for the purpose of ad hoc or in charge, that remains.
My submission is that
all that to file your reply. Should notice also, or the respondent shall file its reply after 3 weeks.
Item 20.
So notice should also go to the private respondent.
4 weeks cut. By ordinary as well as registered post returnable.
Obliged.
Item 20.
My lordship, my senior is on his legs before another court. Please pass over for the day. Kindly pass over for the day, my lordship. He's on his legs before another court.
What about you? You are with him?
I am not ready with the case, my lordship.
Why?
Because my senior has given me file today only.
You are serious? Why should you read all the files which are there in the office?
I will come.
You were not there in the office yesterday?
No, my lordship.
Why?
I was outside Patna, my lordship.
There is no way. Can't be appearing in the court like this.
Pardon, my lordship.
There is no such pardon or sorry or thank you in the courts. Once you wear a gown, you have to be responsible towards it.
I will come prepared tomorrow.
The petitioner wants time to prepare the case, just again tomorrow. He will argue the case.
Item 21.
My lord, petitioner is a super, my lord, in the EAV public school, Bihar Sharif, my lord. In this case, my lord, he has not got the salary.
There are two of them.
My lord?
There are two of them. Both of them are working in the same place.
Same school. In the same school, my lord, as a sweeper. In fourth year reply, हुजूर ये लोग 2006 से.
What are you claiming then?
मेरा क्लेम ये है कि ये हमको सैलरी फिक्स सैलरी देते हैं, जबकि जो एफिलिएशन बायोलॉज है उसमें साथ दिया हुआ है, नो ऑब्जेक्शन जो मिलता है किसी भी स्कूल के एप्लीकेशन का, तो उसमें है कि उसको आइदर स्टेट गवर्नमेंट की सैलरी देना है, नहीं तो सेंट्रल गवर्नमेंट की सैलरी देना है, सारी सुविधा देनी है उसको. और ये लोग 10 साल से सबको खटा रहे हैं उसी ढंग से. 16,000 9,000 से शुरू किया, 16,000 दे रहा है. और जब हम क्लेम किए तो हमको कह रहा है कि कल से काम मत करो, और नहीं तो कॉन्ट्रैक्ट बेसिस पे करिएगा तो करिए. बंधुआ मजदूरी बना के रखे हो. हमने लगाया है आरक्षण कि जो लोग जो लेते हैं एफिलिएशन सीबीएसई से, तो स्टेट से जब नो ऑब्जेक्शन लेते हैं तो उसमें लिख के देते हैं कि हम देंगे.
File your reply. In the meanwhile, no coercive step shall be taken against the petitioner.
At present, they are not working. They are working. No. They have themselves deserted the school, my lord. No, man.
You got the notice and after that you have done it, you will take action.
No, my lord. If you lord
we have said we have protected their rights. No coercive step shall be taken against them.
Provided they are working in the school, my lord. My submission is that they are not working in the school.
Item 20.
File your reply.
Oblige.
Item
Yes, madam. I am appearing on behalf of the petitioner, madam.
Yes.
This case is with regard to appointment of block teacher, my lord. And there is continuous litigation, my lord. Now the annexure 15 is the impugned order by which the state appellate authority.
What is the appellate authority's order?
That is at page annexure 15 at page 16. He filed the learned state appellate authority has allowed the petition filed by the private respondent by way of quashing my appointment.
Who is this person who had filed the appeal? The appeal filed by this petition.
Appeal was filed by the private respondent against the order passed by the district.
In what capacity did he file it?
What is this?
What is his capacity in filing this appeal? What was his locus?
Actually, my lord, there were several rounds of litigation and all the appeals were filed, excepting the original one.
But what is the relief granted to him?
My lord?
In this order, impugned, which you are challenging, annexure 15 you are challenging. What is the relief granted to the...
Respondent number 7. He was, by the order passed by the district appellate authority, the appointment of respondent number 7 was quashed. And against which he came before the state appellate authority.
That's what we were asking you. Where is the order of the district appellate authority?
My lord, kindly allow me to place the facts. There are several rounds of litigation. सिर्फ 7-8 राउंड लिटिगेशन लगा, लास्ट में ये ऑर्डर वजूद पास हुआ। बता देंगे को 5 मिनट में हम।
हाँ बताइए।
This is with regard to the appointment of block teacher in the year 2006 pursuant to an advertisement. My lord, both the candidates, the private respondent and the petitioner, both belong to SC category, male category, my lord. And the petitioner has got higher marks than the respondent number 7. But in the merit, when the merit list was prepared, the petitioner was not appointed. Petitioner was not appointed in spite of the fact that he had higher marks. He had 53% and the respondent number 7 had 52 points. My lord, thereafter I filed, at that point of time there was no provision of filing an appeal. I filed my objection before the district appellate, before the district magistrate and the DDO. But no action was taken. In the meantime, the provision of appeal came. And then I filed an appeal before the district appellate authority. That appeal was allowed, my lord. And against that order, the petitioner was appointed. In the meantime, the respondent number 7 was appointed pursuant to the merit list, which was challenged by me. And the respondent number 7 came before this honorable court only on the ground that while passing the order, the district appellate authority has not noticed him. That is principle of natural justice. My lord, with that the order passed by the Honorable High Court is at page 28, my lord. That is annexure 4. Kindly come to that order. Kindly come to only on the ground that he was not heard. I'm reading the relevant lines, my lord.
So what happened then?
That was remanded to district appellate authority. That was remanded only on the one point that if he was not heard, it is violation of principle of natural justice. If the fact is correct, then he may be heard. Then the respondent number 7 file an appeal before the district appellate authority. District appellate authority that he should be heard. And after hearing him, the appeal was allowed.
His appeal was allowed.
His appeal allowed.
So the earlier appeal, which was your appeal was allowed, that was set aside by the High Court.
Set aside. That was set aside and remanded.
So what happened in remand?
And he filed, the respondent number 7 filed an appeal before the district appellate
So
authority.
in remand he filed an appeal?
Yes, my lord.
So that originally was not heard?
Heard.
All right, then.
Petitioner filed appeal.
So the order was passed in his favor?
The
order was passed by the district appellate authority ultimately in his favor?
In his favor.
Then?
And uske baad was allowed.
Then you must have challenged that order?
The petitioner filed, he was directed to file appeal High Court में आया, फिर order हुआ कि जब जाइए district appellate authority के पास उसको district appellate authority मेरा ये allow किया. Ultimately allow किया, I was appointed, I was working, and again the respondent number 7 came before this Honorable High Court, that was remanded, and again the instant writ application has been filed, which was that was allowed. Therefore, the district appellate authority allowed the appeal filed by me, and therefore against that order, the respondent number 7 came before the state appellate authority, in which the annexure 15, the impugned order has been passed. Impugned order has been passed. Considering my submission for your lordship's consideration is that in the your lordship, as I have stated before your lordship, that there are several rounds of litigation, and my submission is that the impugned order has been passed, taking into consideration the preliminary objection. At that when the first phase of appointment was made, then at that point of time there was no provision for appeal, and
that has been taken into consideration too.
My lord?
That has been taken into consideration for setting aside. That is the ground.
That is one of the ground is that second phase में हम पढ़ देते हैं उसको.
Issue notice.
I am reading from
the counsel for the state for the petitioner submits that the state appellate authority, by its order dated 28/4/22, has set aside the order passed by the district appellate authority on the ground that the district appellate authority was not competent to decide disputes in respect to grievances during first phase of selection of panchayat teacher. Learned counsel submits that the orders passed by the district appellate authorities was in pursuance of the orders passed by the High Court, whereby the High Court had remanded the matter to the district appellate authority for consideration. In view thereof, the view taken by the state appellate authority is erroneous. Issue notice in the meanwhile, effect and operation of order passed by the state appellate authority shall remain
Respondent number 7 has appeared, my lord.
Shall remain state. 28/4/22. Reply may be filed within case for the respondent. Number 7. He may file his reply if he so chooses.
Copy. It is the system of the High Court after serving the copy of the.
He is appearing as a cavator.
Private response, yes, I will.
Respondent number 7.
Yes.
List after 4 weeks.
Item number 23. Chaturvedi Srivastava.
Your Lord, Lordship, respondent number 7 is working in the light of.
We don't know.
I will file within 2 weeks, my lord.
You have not filed a KVIT. We were checking whether you have filed a KVIT. You have not. That is why you did not stand on the dais.
My lord, I will file.
Now you may file whatever you have to do.
Within 2 weeks, I will file, my lord.
All right.
Order.
We have stayed the order. That's it. You may move appropriate application if you want. Yes.
Your Lordship, please, my lord. In the present case, my lord, the petitioner seeks to challenge appointment of respondent number 7, my lord, against the post of Assistant Professor in Public Administration.
Issue notice. Returnable 5 weeks by ordinary as well as registered post.
A date may be given, my lord.
After 5, you have to get them served and thereafter you move.
Respondent number 7.
Respondent number 7.
Item number 24.
My lord. My lord, the petitioner retired as commission principal, but my lord, difference of salary of the petitioner has not been paid. My lord, by annexure 5, the issue has been decided with respect to...
Reply. 8 weeks.
Item number 26. Rakesh Kumar Pandey, Mr. Sunita Mishra, and Mr. Surya Narayan Shah. Item number 26.
No one appears for the petitioner. Interest of justice, test this case after 4 weeks.
Item number 28. Shashank Chandra.
May I please, Your Lordship? My lord, the said application has been filed at a limited grievance. The petitioner is praying to direct the respondent BSCB to rectify the name of the mother of the petitioner in the records of Secondary Teachers Eligibility Test Examination 2019. My lord.
My lord, sir, my specific pleading in my counter academic, paragraph 8 or 7 and 9, my lords. They were keeping in view of the interest of the candidates, my lords, number of times, my lords, advertised for rectifying the name of the, my lords, any discrepancy in the, my lords.
Then what?
Then he has not, my lords, availed the opportunity and the honors of the given to the board.
When has he moved this application?
Yes, never, my lord. My see, paragraph 9.
You don't want to. You don't want to correct it.
He has not come to the court, to the office.
That's all. That is the only ground.
My lord, paragraph. My lord, may kindly see 9. The advertisement 39.
That you have argued. That you have heard you.
My lord.
Anything else?
So therefore, sir, he malified intentionally to secure the honors of the board.
Where is the malified here?
Malified with the number of opportunities. But he is not
How is that a malified?
Malified means time, so therefore he is not availed the opportunity. So
all right. At best you can impose a cost on him. His mother's name has to be corrected.
No, I'm giving the opportunity. But he has not availed.
The petitioner has, by way of this writ petition, prayed as under. A counter affidavit has been filed by the respondent stating that the board had, after declaration of the result, issued notification by advertisement dated 13/9/2019, 27/9/2019, 16/12/2019 and 23/12/2019, providing opportunity to the candidates for making necessary corrections, for seeking necessary corrections in their details. Thereafter, the examination was conducted and the result has been declared. Once the result has been declared, the details in the result need no correction. And it was the duty of the petitioner to have corrected his details prior to participating in the selection process. I have considered the submission. In Jigsaw versus Central Board of Secondary Education, 2022, 1 and 4 SCC. The apex court has held as under. In view of the law laid down by the apex court, the right of the petitioner to get corrections done in the certificate of name of her mother exists, and considering that there is no considering that the application has been moved for correction of the certificate by the petitioner, it is responsibility of the respondent board to make the necessary correction after verification. In view of the judgment passed by the Supreme Court and directions given therein, similar directions are given to the board to take steps and after verification make appropriate corrections in the certificate within period of 2 months, 1 month. This, if required, necessary cost for making corrections may be demanded from the concerned candidate, which he will deposit with the board.
And subject to my lord's correction, my lord, it is reported in 2021
7 is. Oh, correction. Five, three, five.
Item number 29.
Initially, my lord, application filed for recall of the annexure 1. Initially, application was filed for recall of the annexure 1. इसमें हमारे मार्कशीट सर्टिफिकेट को फेक डिक्लेयर कर दिया है। रेस्पोंडेंट नंबर 6 का काउंटर एफिडेविट आया है, उन्होंने रेक्टिफाई किया कि हमारा मार्कशीट सर्टिफिकेट सब जेन्युइन।
तब क्या रह गया?
annexure 1 का कोई साइंटिटी नहीं रहा है इसको विद रिस्पेक्ट टू पिटिशनर नंबर 1 जो फेक डिक्लेयर कर दिया है।
So they have redressed your grievance.
Yes, Lordship. We have redressed.
They have redressed their grievance.
ये annexure 1 विजिलेंस का है।
विजिलेंस की तरफ से कोई आया है? I will believe them as party.
हाँ, पार्टी बनाया, काउंटर भी आया है उनका।
Yes, so you appear for the state.
Yes, I am for everyone.
So he appears for all of them.
ना विजिलेंस के लिए अलग है।
अलग है।
विजिलेंस के काउंसिल अलग है।
काउंसिल तो हम तो गवर्नमेंट काउंसिल एक ही मानते हैं।
विजिलेंस के
they may engage many people who is stopping them. For government there has to be one council. If he chooses not to appear, that is his response. The petitioner assails the order, annexure 1, whereby his certificates were treated as forged and fake by the vigilance bureau. The petitioner asserts that the certificates and issued in his favor were true and correct, and no forgery had been committed. He therefore preferred this writ petition, impleading the board as a party as well as the vigilance and the state government. The counter affidavit has been filed on behalf of respondent number 6. That is the Bihar School Examination Board, who has affirmed the contentions made by the petitioner and has stated that stated in para 5 of their counter affidavit as under. Para 5
Para 7
in para 7.
10 में क्लियर किया हुआ है पैराग्राफ 10 में
Annexure B, we have informed the vigilance.
The vigilance department has also been informed by the board via their letter dated 20th January 22. The district program officer has also filed its counter affidavit mentioning that the salary has been paid to the petitioner. No one appears for the vigilance department, while the state council appearing for the respondent department does not object to the contentions as noticed above. This court finds the vigilance department has recorded in its letter dated 23/9/21 about the certificate being fake. The counter affidavit filed on their behalf refers to an order passed by this court in a PIL. However, this court finds that the order passed by the High Court nowhere directed that all the certificates filed by concerned teachers should be treated as forged or fake. There has to be an independent application of mind and verification has to be done from the concerned board before lodging of a complaint against any teacher. This court notices that on account of a wrong interpretation of this court's order, several cases are coming up before this court where, taking umbrage of the order passed by the High Court, Vigilance Department or the concerned district education officer are issuing orders alleging the certificate to be forged and leaving it upon the concerned teacher to prove that his certificate is genuine. The intention of the court's orders are not for the purpose of harassing the already appointed teachers, but to see that no person with forged certificates is employed. A procedure therefore is required to be followed. The harassment caused to the petitioner cannot be compensated. Be that as it may, considering the fair stand taken by the board, this writ petition is allowed. Annexure 1 is quashed. The petitioner shall be allowed to continue and perform the duties. No cost.
Item number 30. Sita Shah.
For Illinois University, madam.
No one appears for the petitioner. Just after 4 weeks.
Item number 31. Shri Bhushan Singh.
My lord, the petitioner went in some training of my lord DLED course of session 2017-19, my lord. He appeared in session part 1 and in the supplementary examination of part 2, my lord. But the mark sheet which was given to the petitioner, that is annexure 4 at page 18, the marks of practical was not given in the mark sheet, my lord. Then he approached before the NIOS. The principal, then he went to the study center. One of the study center has written a letter, that is annexure 5 at page 19, to the my lord NIOS कि मानवीय भूल के वजह से ये प्रैक्टिकल का मार्क्स नहीं दिया गया। माय लॉर्ड न्याय परमिट में चोरी उपयुक्त विषय के संबंध में अंकित करना है कि इस विद्यालय में डीएलएड और प्रशिक्षित कोर्स 2017-19 में इन्हें नामांकित किया गया था। इनका एनरोलमेंट 1600 है। प्रशिक्षण इस महाविद्यालय के लिए केंद्र बनाया गया था, लेकिन अंक अभी तक अप्राप्त है, परंतु कुछ मानवीय भूल के कारण से इनका व्यवहारिक पेपर के कॉपी पर अंकित नहीं किया गया है। अतः my lord, that is annexure 5 at page 19. This letter had been issued by my lord the principal of the college of the study center and forwarded to my lord the regional director in iOS. My lord, by annexure C, my lord, in which my lord the petitioner has requested the principal of the college to provide the number of the marks. Then my lord, in that representation, the number of marks in all the practical paper has been mentioned, that is at page 21, and this representation was forwarded by the principal of the college, my lord, at the top, my lord, left side.
What happened?
My lord, no, my lord, even then, my lord, the result of the petitioner has not been published. So my lord, no latches on the part of the petitioner. Due to latches on the part of the...
What is their counter?
My lord, no specific counter, the general counter has been filed, my lord.
NIOS is appearing? You have included them as parties?
Yes, my lord.
Who appears for NIOS? Where have you included them as parties?
My lord, I have filed an IE application for impleading.
Regional Director, National Institute of Open Schooling.
Have
they been served?
Yes, my lord. I have served.
On whom?
My lord,
when you don't know where have you served, how can you be issue notice to respond number 7? Returnable within 4 weeks. Dusty.
Item 33.
Lordship. In this case, Lordship, the DPC, the matter of petitioner was not placed before the DPC, only on the ground that on the day of DPC Lordship, I was under suspension and under departmental proceeding Lordship. And they did not consider, instead of keeping, at least adopting the seat cover Lordship.
They have filed counter.
What is the procedure? What is the procedure for DPC? That if a person is under suspension, his case shall be considered.
Sealed, at least sealed covers should be followed.
There has to be some procedure. They must have laid down some procedure for DPCs. Or is there no procedure here laid down?
Procedure they have.
आप सील कवर प्रोसीजर का कोई सर्कुलर निकला हुआ है कुछ, ये तो आप ही पता करेंगे ना. What do they say in their counter?
They are saying that he was under suspension, therefore his matter was not placed for consideration, and subsequently I have been exonerated. I have been exonerated from the departmental procedure. Now paragraph 7, 8 and 10, they are saying that I have been exonerated, and in paragraph 10 they are saying that in forthcoming DPC they will consider.
Your Lordship, in paragraph number 11, it is stated that due to the restriction imposed by the General Administration Department, Bihar, is due to which adversity is being faced to redress the grievance of the petitioner.
It is difficulty, not adversity mentioned here. Where is that GID order? Where is that order of restraining?
Your Lordship.
DPC for what?
For promotion, Lordship, for promotion to the post of headmaster, Lordship.
The petitioner has referred this petition for questioning and setting aside the decision of the District Primary Teachers Promotion Committee dated 28/12/2016, whereby it decided not to consider the case of the petitioner for promotion on the post of headmaster on account of pendency of suspension or departmental proceedings against him. Learned Counsel submits that the petitioner's case ought to have been considered and his right of constitution cannot be taken away merely because he is under suspension. Learned Counsel has further pointed out that the petitioner was reinstated and exonerated in the departmental inquiries by order dated.
Lordship. By order dated and actual Lordship.
And
it is annexure 5/1, Lordship, case 24. Annexure 5 and 5/1, page 23 and 24. Revoked from suspension and dropped. आरोप प्रमाणित नहीं होता है.
By order dated 26/5/2018. Keeping in view thereto, Learned Counsel submits that his case was required to be reviewed by the Departmental Promotion Committee and considered afresh from the date his junior has been promoted. Per contra, Learned Counsel appearing for the state submits that after the action of not considering the case of the petitioner while he was under suspension is correct and is in accordance with law, and after the petitioner was exonerated of the charges, his this case would be again considered. However, on account of there being an embargo laid down by the General Administrative Department of not making promotions, via their memorandum dated 11/4/2019, the Departmental Promotion Committee cannot be convened. It is stated that as soon as the said embargo is lifted, the petitioner's case shall be considered for promotion. I have considered the submission. In Union of India versus KV Janki Raman, AIR 1990, Supreme Court, page 2010, the apex court has considered the aspect where a person who is in cloud, that is, whether he is under suspension or when there is a departmental inquiry proceedings pending, how his case has to be considered. Several different examples have been considered by the apex court, and it has been held that a right of consideration for promotion exists with an employee if he is under suspension or a departmental inquiry is pending. His case has to be considered, but shall be concealed cover, which would be opened subject to the decision of the departmental inquiry. Para. It would be opposite to quote the relevant para of the apex court judgment as under. Para. Next. Keeping in view above the action of the respondent in not considering the candidature of the petitioner for promotion, when he was under suspension, is found to be illegal and unjustified. Stop. At the same time, taking notice of the fact that the petitioner has been subsequently exonerated, case for review of DPC is laid out. The embargo laid down by the General Administrative Department as pointed out by the respondent dated okay, 2019 का है ना 2019 would 11/4/2019 restraining the respondent from convening meeting of Departmental Promotion Committee has to be understood in the aforesaid circumstances. The said directions for not convening meeting of Departmental Promotion Committee is for the future promotions and not for the purpose of review DPCs. A review DPC is essentially a DPC to be convened to take into consideration the case of a person who has been left out for unjustifiable reasons for promotion while his juniors have been promoted. Admittedly, the petitioner's case was not considered by the original DPC. In view of above, directions are required to be issued. Stop. The petition is allowed accordingly. Directions are issued to the respondents to convene a review DPC for making promotions on the post of headmaster and consider the case of the petitioner. from the date his junior has been so promoted. The exercise shall be conducted within period of 2 months henceforth. Writ petition is allowed, is before no cost.
Item 34. Arun Kumar. This case belongs, I pray for further 2 weeks time. I counter the
Counsel for the respondent wants time to file counter. As the last opportunity, 3 weeks time is granted. List after thereafter.
Item number 35. Arvind Kumar Singh.
May I proceed? Now, by this writ application, challenge is constituting of ad hoc committee. Now, in the meanwhile, one of the member, as per the last occasion they have submitted, respondent number 7 has been removed, and in his place, another person has been appointed, for which, my lord, I have filed IA number 2 of 22 to add person Kumar Singh duly appointed and to issue notice to him.
The senior counsel appearing for the petitioner has taken this court to the IA number 2/22.
My lord.
With the prayer to impede the newly appointed member of the committee as a party to the writ petition. For the reasons stated, the IA is allowed. Amended cause title be filed. Registry is directed to place the same appropriate place. Issue notice to the newly imputed respondent by order as well as registered post returnable.
Since my lord has stayed to order, my lords, the college has come to a standstill. My lord. No financial transaction is being done. Even salaries, admissions, it is yet. My lords can direct the registrar to perform the duties. Since the account has to be operated, salaries have to be done.
The counsel appearing for the university submits that since there is a dispute relating to the functioning of the committee, the interim order was passed by this court. However, the same has resulted in non-payment of salary to the staff and other employees. And it is suggested that in the meanwhile,
the finance officer, anybody, my lords,
any official of the university may be asked to perform duties as an administrator till the issue is resolved by this court. Taking note of the submissions which this court finds to be fair and in accordance with law, this court directs you have the controller of examination is there, and who all authorities are there with you?
My lord, the state authorities are also there.
The state authorities, my lords can direct the controller of examination and the finance officer or the inspector of colleges.
He is also a member of the university.
My lords, inspector of college is a teacher who is appointed by the Honorable Chancellor, my lords, as inspector of college.
The inspector of college.
Arts or science, both are different, my lords. My lords can indicate that.
Science, who is nominated by the chancellor in the university, shall act as overall administrator and will have the drawing and dispersing powers to maintain
for payment of salary
for the purpose of releasing the salary and other funds for the regular day-to-day functioning. However, he shall not take any policy decision. List this case immediately after service of notice. The court on date with 5 weeks.
The examination, the inspector of college science.
Inspector of college science.
My lord, I am appearing on behalf of respondent number 8 in this case.
Counsel appears for respondent number 8. And newly appointed respondent also you appear?
No, I was already there.
All right.
My lord, the name is not appearing on the list.
The name of appearing for respondent number 8 shown in the cause list.
My friend is senior and how his name will appear on the list?
I'm not sure.
Make him senior.
Yes, my lord. I regard him as senior. He's my good friend.
That's be shown in the cause.
If I could just point out, my lord, the forms could not be submitted. So in that sense, also some clarity.
Have you filed your wakalat number?
My lord, yes, I have filed the wakalatnama. I filed it
along with the court fees.
Everything, my lord. Yes, I have already done that, my lord.
Item 36, Mr. Sushil Kumar Jha.
Lordship, in this case, Lordship, after direction of my lord for release salary of the petitioners, the respondent have filed counter appeal saying that the state government has recommended cancellation of petitioners' school, Lordship. And thereafter, I have filed 122, Lordship, for modification in my
Do you have any objection to that IA? Likhe, an IA has been filed.
Lordship, here he is coming.
Seeking amendment in the writ petition. The respondents have not objected to the same. Taking into consideration the reasons mentioned in IA, the same is allowed. Amendment as requested is allowed to be made in the writ petition. Amended writ petition be filed. Counsel for the respondents may file a counter to the amended writ petition. If they so choose, list this case after 4 weeks.
Item 47, Vinodanand Mishra.
May please, Lordships.
Yes.
Lordships,
My lord, I have filed counter affidavit in this matter, but hard copy is already.
Counter affidavit on behalf of respondent number?
University Service Commission.
Respondent number 1.
Respondent number 3 to 5.
Learned counsel appearing respondent number 3 to 5 state that they are filing a counter affidavit. The same may be placed accordingly. The file by the registry lists this case again after 3 weeks. In the meanwhile, reply to the counter affidavit. Pending may be filed.
Shorter time may be given. Selection.
2 weeks.
And also the date.
आप पहले reply to the
Date.
That's some this case. Along with 38.
38, my lord, in this case, in my case, if some date is given, that is. Otherwise, I am ready to argue. The previous 37.
37 is over.
If date has not been given, that's how it will not come in the same
No,
way.
we don't give dates. When there is a counter to be filed, reply to be filed, let it come after that. But the pleadings may be completed.
I need not to file any rejoinder, Lords, because.
All right. Sorry, will not give a date.
Item 38, my lord, I am appearing for the university.
Whose IA is this?
My lord, I have filed an IA
for what?
Petitioner. That is, I have mentioned that during pendency of this writ application.
Urgent hearing.
Urgent hearing.
And passing interim direction.
Thereafter, the matter was taken up and order for the counter affidavit was passed in this case.
My instructions have come, my lord. I just need to get the affidavit done, my lord. Only that part is left. I have received the instructions of the university.
You have not filed your counter even after that.
I have received the instructions, my lord. Only.
You will direct you to at least allow them to appear.
My lord, that they are already doing, my lord. That they are already doing. There is no impediment in their appearing, my lord. I think. The only
The IA has been filed by the petitioner stating that the respondent university be directed to accept the fees and forms of the petitioners for ensuing examination of BE, BS, BCA and allow them to appear in it. Learned counsel for the university states that he has instructions to state
They are taking money thereafter.
that they are not being disallowed to appear in the examination.
Yes, they have not been disallowed.
Keeping in view thereto, the IA stands. IA is found to be the relief claimed in the IA does not require any directions. the I stands disposed of. Rejoinder, counter affidavit within 2 weeks. Rejoinder, if any, may be filed thereafter within 2 weeks, just after 4 weeks.
Okay. Okay.
Item 39, Kumar.
My lord, the writ petition was filed for holding the examination B.Pharma course for 2021 session. After submitting 2 contradictory affidavit by the respondent university, yesterday I received a supplementary in which they have taken their stand that was taken in the first counter affidavit that they are going to promote the students as per the notification of UGC. My lord, last day there was.
What is your stand, Mr. Controller of Examination?
Sir.
What do you say?
Sir, recently the affiliation was not granted to this issue and we have not got any information from the affiliation section. That's why we couldn't implement the same notification to the respondent university. But we talked to the Vice Chancellor and we have placed all the facts, what was happened, and in the first affiliation what was granted to them that they will have to improve there were 2 deficiencies pointed out in the inspection report. Perhaps they have submitted and we are in process and we will affiliate it, we will place the matter before the Board of Affiliation within 2-3 days and we will affiliate them and accordingly will promote them according to the notification of issued in the COVID period of the UGC.
Okay. Counter affidavit has been filed when?
My lords, it was filed yesterday, my lords.
The controller of examination is present. He states that certain deficiencies were found which resulted in the delay in affiliation of the concerned college. It is stated that the said deficiencies have been removed. The matter is to be placed before the Board of Affiliation, who will take a decision within 2-3 days. The Vice Chancellor has also taken a decision to allow the students to be promoted.
As per the UGC notification.
As per the UGC notification for the COVID period. A counter affidavit in this respect has also been filed by the university. Taking note of the aforesaid facts, this writ petition is disposed of with directions to the university to take immediate steps with regard to affiliation and also
promotion of the students.
Issue necessary orders for promotion of the students and subsequent studies in the future classes.
Lords, within a week.
It is also directed to the controller of examination to take necessary steps in the university for conducting year-wise examinations in terms of the provisions of this Act, so that the future of the students is not jeopardized. In order to see that the future of the students is not jeopardized.
What's the necessary orders
The
would be
petition,
passed within a week. The necessary orders would be passed.
That is what we have said. The writ petition is accordingly allowed.
Item of 40.
My lord, in this present writ petition, prayer number 1 and 3 kindly permit me for withdrawal, my lord.
Let's say they have filed.
And what about 2? You still want to continue with 2?
My lord.
What is that? I want to challenge this notification of 822.
My lord.
They have filed a rejoinder to the counter affidavit of respondent.
Learned forms for the petitioner does not press prayer number 1 and 3 to the writ petition. However, he presses his prayer number 2 with regard to the challenge made to the notification dated 8/6/22. Learned Counsel for the University may file its counter.
Esteems, I'm for the respondent of 5 minutes.
Counter to with respect to prayer number 2 alone.
Let's
आपका काउंटर नहीं है ना? You filed a counter. What do you say with regard to this order of 8/6/22?
The presenting this case is arguing court number 6. Therefore, Lord, I would just pass out for a few cases.
Lord, in this
Yeah,
case,
you learned counsel for the university. States that they have already filed their counter and will restrict their counter to the said prayer alone. What do you want?
I'm appealing for the respondent of 5. Lord, when
you want to file a reply?
I want to file a reply to his rejoinder, and your lordship, I want to communicate this.
Reply to the rejoinder?
But I want to see that rejoinder because I have not seen your lordship. Secondly, your lordship, that I have been arraigned party subsequently, your lordship, when I was posted at the place of the petitioner, writ petitioner.
That is your contention. We will examine it that time. Learned counsel for the
his withdrawal
point number 5
do not prejudice my rights, my lords.
Rejoinder, which may be made available to you. List again after.
Let's just think. His withdrawal should not prejudice my rights, your lordship, because we are also questioning that order of withdrawal.
That is exclusive domain.
That is.
Whether it prejudices your rights or not, that you take up.
Item 41, Mr. Kumar Mishra.
May it please your lordship. May I at the outset request my lord to kindly see the previous 2 orders before I take your lordship to the facts of the case, your lordship. The pleadings are complete, my lords.
Pleadings are complete.
My lord, the university has already filed counter. The private respondents are also filed counter as well as reply to my 3rd supplementary affidavit, your lordship.
All right. We will
So, my
take
lord,
up some other day. We have only half day bench today.
my lords, with your permission, if I could submit.
Counsel for the petitioner submit that the pleadings are complete. The matter list this case for final hearing.
रीडिंग में कमी है उस मेरे तरफ से नहीं हुआ.
My lords, since I am seeking an interim protection, my lord, they have.
Pleadings are complete. However, learned counsel appearing for the commission wants time to file reply. He may file his reply within 2 weeks. List this case in hearing thereafter.
My lords, may I submit, my lords? My lords, since I am seeking stay order, your lordship, of the appointment letter issued of the private respondent, my lord, because we have got document through RTI saying that the experience certificate which he has produced at the time of appointment, the university said that they have not issued any such experience certificate, your lordship, and thereby the 10 marks which he has been awarded, your lordship, because he has got 97 and I have been given 96, your lordship. So, my lords,
Learned counsel for the petitioner presses his prayer for stay and prays that he responded number.
I'm so sorry. Respondent number 5, your lordship.
I have a query for respondent number appointment.
There is already interim protection subject to result, my lord.
Yes, that I have seen.
If any appointment is
I am being informed that
restrained from functioning. However, this court has already protected the rights of the petitioner by directing that the appointment of the petitioner respondent is subject to the decision of this case. Keeping in there to no further interim order is required to be passed. Yes.
Item 42, Mr. Arun Kumar. Instruction has been received, my lords.
Yes.
May kindly be on Monday, my lords. In the meantime,
As a last opportunity, 1 week's time is granted to file to comply with the order passed by this court dated 9/11/22. List this case again on next Monday.
item of 43.
Please, Your Lord.
My lord, the similar issue has been decided, my lord, by this honorable court, my lord.
What is that?
The transfer matter, my lord, of school teacher, my lord, and the respondents were directed to consider the representation.
Kudu? Give him a copy.
I'm giving.
Let him agree with this order. Then only we can pass a joint. डिसाइड कर दे इंस्टॉल पे कर दे हाँ ये ना all right both the counsels are adamant that the issue involved in the present case can be concluded in terms of the directions issued by this court in the case of
CWJC number 2 केस है CWJC number
वही लीजिए जो उन्होंने अग्री किया है
20
दो कॉपी
6
दो कॉपी
दे
20647 on 2019 Dharmendra Kumar Singh versus State of Bihar decided on 16/8/2019 wherein the court passed following order without entering into the merits. Keeping in view that the aforesaid order shall apply mutatis mutandis to the present case too. Stands this.
item 44 Ajit Kumar
I challenge the annexure 14 and 17, Your Lordship. And on IA, I also filed, Your Lordship, for challenging the inquiry report.
आइए
इनका
आइए नहीं है learned counsel submits that he has filed an IA
and rejoinder also, Your Lordship.
and rejoinder. Registry is directed to place both the same on record list afterwards.
item of 45
Lords, at the very outset, Lords, I would pray for one more indulgence, Lords, to file the counter affidavit on behalf of the state.
As a last indulgence, 3 weeks for the time is granted to file reply after 3 weeks. तीनों cases में?
Yes, Lords.
In all the 3 cases.
Item of 46, file is not available today. Item of 47, Avanish Kumar. Item of 47.
Yes.
Lords, I am for this. The petitioner has come here, Lords, against the order for suspension, Lords.
Yes.
However, Lords, a counter affidavit has been filed in this case, stating therein that the departmental proceeding has been initiated, Lords, by serving a copy of the memo of charge to the petitioner, Lords. So
what is the charge against?
What just happened, Lords, in this case that he was a teacher and he was at particular point of time, Lords, he was listening the inJudge minutes. When an A&M reached the school, Lords, for vaccination purpose. And according to the allegation that he misbehaved with the A&M, Lords, and subsequently an FIR has also been lodged, Lords.
What's that? That is not a ground for keeping him under suspension. What will you do? What is the purpose served in keeping him under suspension?
Lords, in contemplation of the proceeding.
All right, but then after the charge sheet has already been used, it will take time.
Lords, disposal of, Lords, with the direction to complete the departmental proceeding within a certain particular period.
Why should he be kept under? He is challenging a suspension order.
Yes, that is it.
No one is available on behalf of the petitioner. List after 2 weeks.
Item of 48, file is not available.
Lordship, if about 48, Lordship permits, I shall say I am for the respondent, 4 against me.
The file is not there. Where is the question of my passing the order?
I was seeking time only for filing counters.
But कहाँ से order कर देंगे बिना file?
Lord. I'm sorry.
साहब आप तो
sorry.
Item of 50, with analogous cases.
Lords, matter relates to selection on the post of assistant professor in Hindi. First case is of my senior.
But in this case, we had filed one counter affidavit in one of the cases with regard to the modes of the experts and other things which were decided. And with regard to the other that is ready, my lord, same counter would be required for the others also, which is also in the process, which is also getting ready, my lord. Group cases, my lord.
Counter is filed. First case, the counter is filed. Commission.
Yes, this affidavit which we asked you to file on 25/11/22. Has it been filed?
One case it has been filed, it is getting ready in all other cases. It will be filed, my lord, by this week.
In all the cases, there is the same issue.
Same issue.
That some have been declared eligible.
No, it's like there's a catch. One of the results have been published. It has been notified. Now the successful candidates, they'll have to make them a party.
Have you made it subject to decision?
There is an interim order, not first order, second order.
It has been made, we will be filing subject to. We will also be, my lord, apprising the court of that, my lord. We change of the
three cases, my lords, the candidates securing qualifying marks have not been interviewed. This too is the case.
No.
Candidates.
When do you want?
2 weeks. 2 weeks. Several cases हैं, सब में 51.
2 weeks further time is granted as the last intelligence. List this case again on 30th January.
And as we also bring the, my lord,
30th January is all right?
The change in circumstances.
30th January is all right with you?
All
or is it 1st of February?
1st of February will be all right. 1st of February.
Whichever date.
1st of February.
1st February.
My lord, still date no appointment has been made. Therefore, they be restrained from making appointment.
Lord, my only request, Lord,
it is made clear that appointments, if any, made will be subject to the decision of this case.
Lordship.
These cases.
Position may be ordered to be restrained.
अरे भी डेट दे रहे तो फिर
Item of 51.
डेट पे तो आ ही जाता केस और कोशिश तो यही रहती है कि सारे केस ले लें पर लेकिन जितने हो पाते उतने ही होंगे.
Item of 51.
Lords, in this case, counter affidavit as yet has not been filed.
लास्ट इंटेलिजेंस काउंटर एफिडेविट भी फाइल्ड, इसमें भी कर दीजिए अगेन ऑन another डेट दे दो उसको.
पुष्पा एंड ललिता 8
तारीख ललिता में, पुष्पा एंड ललिता में.
Requirement says that any journal should be published in UGC listed journal.
अरे
or
अब वो
PF.
फैक्ट्स आप बाद में बताना. There are other cases also, Mr.
My lords, in this case also,
Same counter.
teaching counter has been filed. Counter has been filed. Marks is not being granted for teaching experience. It almost are the same. Can be decided in
But
one
they
go.
have to be decided separately. This is for teaching experience.
Teaching experience as well as non-grant of marks for journals. Journals. And in those cases also the same. Is
So for that we had asked you to give us the entire details, sir.
Yes, my lord. That's why I have filed in 2 cases.
All right.
And I want to file.
ये तो फिर थर्ड को ही रखें.
हाँ उसी
फर्स्ट को ही रखें.
हाँ फर्स्ट को ही रखें.
वो दोनों भी फिर फर्स्ट को ही.
हाँ सब वही है. सब में आइटम
फर्स्ट पे रखिएगा.
क्योंकि 2 cases में I have filed as per the direction of the my lord order.
Sorry,
That's why it required same
item 50 is the same case, my lord. And there, my lord, they have filed the counter affidavit pursuant to what is possible.
कर दिया ना. सब केसेस को फर्स्ट को रखना.
On first.
You should keep a unit with you, Mr. Who should inform you what is happening in the court. If you are in some other court, somebody else should be there here.
I was right next to this court.
It might be, but somebody else has to be there with you.
My lord,
Keep at least 2-3 juniors with you.
Of course, my lord. I'm sorry for that.
No, what is sorry? You are not doing it.
I had asked, my lord, they just are afraid to appear before my lord. So, my lord starts asking them questions they don't want to answer. This is the problem.
This is something. This is required to be done at your level.
I've been trying, my lord. I'm trying on a very regular basis.
You have to train them like that. If they have to be here in the court, they should be ready to answer some questions at least.
I'm trying, my lord. Maybe with passage of time, they will be in a position. It's just that.
Item 53.
I don't know what is the new trend. In our times, the first day I went to the court and the senior made me appear in the court.
We've been following it here also. That's how we all learned. But
I don't think so, lawyers, if they are running away.
We used to grab the opportunity.
Yes.
The absence was the time when we actually got trained. In serial number 65 also, the issue of teaching experience is involved.
These are all same cases.
No, my lords. I'm not talking about
53. This is with regard to declaration of result, my lords. My lord had earlier granted time, my lord. Further 1 week time may be granted, my lord.
For the last indulgence, 1 week further time is granted. 53. To the council for the university to comply with the orders dated 16/11/22. List again after 1 week. Date be dismissed. Mr. Sinha, is there some interest involved in not declaring results? I just want to know from you. Has the university or some officials interest is involved somewhere for declaring of result? Any interest?
Definitely they are having. Now
It's very surprising. Where should anybody have any interest except the students?
Now the new
that their result is declared.
Now the new.
Your officials have interest in the declaration of result, not to declare a result.
No. Now the new VC has come. Now the new regular VC has come. Now the question will all the time.
In result of that, Your Lordship, the admission of the petitioner has been cancelled by Delhi University, Your Lordship.
54, Mr. Kaushal Narayan.
In 53, Your Lordship.
53 हो गया. Date दे दिया.
Item 54, Mr. Kaushal Narayan and Mr. Sushil Kumar Singh. Item 54.
No one appears for the petitioner list after 4 weeks.
Item 55.
May come next week, my lords. Any day next week, please. Payments were to be released, my lords. I had to talk with the finance officer, my lords. It will be done with this week only, my lords. 2,70,000 and 834 is the amount, my lords. Difference of size.
As a last indulgence, counsel for the university is directed comply with the order dated 16/11/22 within 1 week. 20.
Item number 56.
Lordship, reply to counter affidavit is ready to file, my lords.
Counsel wants one file reply to the counter. That is rejoinder. The same may be filed within course of the day. आज फाइल कर दीजिए
जी जी
लिस्ट आफ्टर
काउंटर में ये दिए हैं कि ये
बाद में देखते
Item number 57. Sir Abhinav Srivastava.
May your lordship. In the present case, my lord, the petitioner, on the basis of her own assessment and evaluation of her credentials, my lord, by way of a chart as is contained, my lord, in para 28 of the writ petition, had demonstrated that she was entitled for award of 89 marks. However, my lord, she had,
that is the same
pertains to, my lord, the same.
के साथ लगाइए जो पहले 52 51 52
50 51 52
टैग कर दीजिए इनको रिप्लाई as a last opportunity counter
They have given the counter affidavit in this case.
मैं फाइल सीधी लगाया जाए इसमें भी वो चीज डालेंगे
as a काट दीजिए
अभी केवल इनका मार्क्स बताया
the case again on first
Take your
58. Sir Rakesh Kumar Sharma. Item number 58.
to remind us on first we will take up these matters and we will hear
In one case I have filed.
He has already filed that.
usually first is a half day because we have a division bench also working 31st को कर देंगे first की जगह हाँ
कर दिया जाए
first को there is a problem
हाँ हाफ डे रहता तो एडजस्ट
मैटर्स जितने भी थे 50 51 यूनिवर्सिटी वाले और आप वो नंबर दे दीजिए सब केसेस को 31st को इंस्टेड ऑफ inform the other council also yes
I have got the petitioner lordship by the last order. Order has been passed for filing of the counter affidavit, your lordship.
I have filed counter affidavit in this matter, my lord.
Madrasa board has not.
Oh, sorry.
no this is not your case this is with regard to 100% pension of
Yes, 100% pension of the petition has been forfeited after his retirement, your lordship.
after his retirement before his death or after his death
After his retirement.
after his retirement yes you filed your counter कब फाइल किया all right yes you want to argue you want some time
Time, your lordship. Madrasa board has also not filed in this
for
case.
the time
Madrasa board has not filed counter
what is
affidavit
required only one
because
who has passed the punishment order
because they have passed the order on the basis of the record of the Madrasa board, your lordship.
naturally so we are going to examine it here the record of the Madrasa board are you expecting by any chance
हम उसको जब
the scope is there available with the court to examine it and conduct it you are in appeal or in writ we will only examine the validity of that order
I replied that counter thereafter, your lordship.
council wants time file a rejoinder to the reply list again after 3 weeks
Item number 59. Vinod Kumar Sinha.
yes
My lord, in first case, my lord, I have challenged the order passed by the governing body, my lord, by which the petitioner has been removed. The
counter आ गया क्या आपका
जी नहीं काउंटर अभी नहीं है
counter file करिए दोनों में
Cases will have to go to the governing body, my lord.
notice to the respondent number
Respondent number, my
6,
lord.
7 and 8, 6 to 9, my lord.
6 to 9.
6 to 9 by ordinary as well as registered post, returnable 5 weeks.
Item number 16. Mr. Bipin Bihar Singh.
My lord, in this case, the order contained in Annexure 4, my lord, that is in page number 48, which has been passed by the learned directors in response to the order referring the, my lord, the order of the State Appellate Authority. My lord, in this case, the petitioner have no concern with that appeal, my lord. But a blanket order has been passed by the authority, and in compliance of that, my lord, the director had issued the letter. And for that purposes, I have already done that.
Visharad.
When
they were appointed, they were given appointment.
They have been appointed as a Panchayat Shiksha Mitra in the year 2005. I have passed the Visharad in 1995. I did that graduation, postgraduate in 95.
But that is not recognized for the purpose of appointment, na?
नहीं ना, वो रिकॉग्नाइज है और हम तो बीए के एमए किए हमने अगर हमारा नेक्स्ट 3 हमने